So liens, liens are something that I thank everybody for staying and listening to this, because liens are something that no one wants to deal with. Everybody thinks they're a pain in the butt. And then, but the reality is they're part of every case. So, and so what I say is double down, judo them, and embrace them, and use them to your benefit, and use them to your client's benefit, because you can really give your clients a huge benefit for doing that. And whether you're on the plaintiff or the defense side, resolving the defendants want the liens resolved as much as the plaintiffs do. So that's my message. One of my messages today. So let's talk about liens. So did you know that when you have a medical lien, the medical lien is not to the injured person and not to the lawyer, even though you think it is? Under the statute, and we set it out in here, a lien for medical services is only to the tortfeasor and his insurer. And those are the only ones that are obligated to pay that. There is no lien to an attorney. You don't have to do that. And when they say, hey, we're going to go get treatment here, will you honor my lien? And they make the lawyer sign it. Well, that's a separate contract. That's not a lien. That's a separate contract where you're granting an interest in that case. And that's fine. And I also do letters of protection to clients. We're getting bill collectors, blah, blah, blah. Will you do a letter of protection for me? Yes, I will give a lien to that. And I'll talk about why I want to do that in a minute. But a medical lien it's under the statute, it's in Section 3, it's a very specific thing. You got to send it by certified mail, et cetera, and then the tortfeasor or their insurer knows of that lien. And then that's when that can be enforced, and that medical lien can be enforced. And they have a right to put a medical lien in the case. Right? And so I'm going to jump and talk about, and that's in Section 3, the hospital lien statute. Now, there's also health insurance liens. Now, health insurance liens or ERISA liens are what we all deal with, and we also all deal with the medical liens. I'm going to talk about how to resolve them and those things too. But remember, with health insurance, if it's a local plan or an individual plan that does not cross state lines, it is not governed by ERISA, and you don't have to pay it at all. They have no right to recovery at all under the law of Missouri, the old Schweiss versus Sisters of Missouri of Mary case, where the public policy idea that you cannot that a personal injury case is not assignable. Somebody can't get, otherwise that'd be a big business. People getting hurt and you start horse trading personal injury cases. That's not going to happen. So it's not assignable, so you cannot have a lien for medical insurance benefits paid. However, if it's a multi-state plan, it's covered by ERISA, then you can. And what happens is when you get this notice, we're an ERISA plan, Optum, or one of these places, there's a number of things you want to do. First, you want to say, prove to me you're an ERISA plan. They got to show you the plan document. Prove to me under the plan document that you have a right to reimbursement. You have a subrogation right. What does that say? They got to send that to you. And then there's other things you want to look at. Is what you're asserting in this case, is the medical care really related to this case? Because it might not be. And it may not be related to others, especially if the defendant is defending the case and saying, no, yeah, we did this, but we didn't cause the heart attack. We didn't cause the later sequela from the injury. And then you can say, well, it may be related, it may not be related. And it depends on what the doctors say on that. So you need to look at whether the claim really is related. And the question becomes, someone asked me this after the last thing, what if your person get hurt but the insurance company doesn't know and doesn't tip to the fact? Do you go out and seek that lien? We've had that many times where the health insurance company doesn't know that there's a third-party personal injury case related to that. What I do is I have a kind of I have a don't ask, don't tell policy on that. I don't ask them. They don't know. We're fine. We settle the case. The client gets more money. And if I settle the case and the client gets the money, the insurance company has lost the opportunity to come in and get that lien. But we also should be clear, and I tell this to the client. I said, listen, just so you know, if you have a plan, now I also don't know, they may not be asserting a lien because they may be a local plan and may not be a ERISA plan, and they know that they're not entitled to it. So that's a possibility. But it may not be on their radar. But I say, listen, you got to be careful, because if they sent you a sheet, they'll always get a questionnaire. We paid you these benefits. Do you have any other claims? So you can't lie on that questionnaire. You can't do that. And there's a 10-year statute of limitation in Missouri for breach of contract. So you don't want them to come back later on. So you got to tell your client, listen, I know you have United Healthcare. We probably think they have a lien right. I know they didn't tell you, and I'm giving you this check for the balance of this settlement's $30,000. But just so you know, someone can come back and try to assert this later on. You want to do that in writing in the settlement statement you give them at the end. I don't think you should have to go and invite those claims and go call United Healthcare and say, hey, by the way, da-da-da, you don't want to invite that subrogation lien. But you also want to CYA a little bit in your settlement letter at the end saying, we know this issue's out there, I get what you're doing, and here you go. So you want to do that. So there's a lot of law in ERISA that we set out in here, and we have some recent cases listed here, some very interesting stuff, they have a lien. And there's some even very recent cases where you cannot use equitable ideas to reduce a lien under ERISA. If the plan document says they get 100%, they get 100%. And there's this recent case I talk about Montanil, and it's interesting. So they can come back after the amount you get in the personal injury settlement, but if you dissipate that, if you get rid of that money before they come and get it, they can't go after your personal assets. So they cannot come take your house. But I have a lot of ways I deal with ERISA. First of all, I ask them to reduce it anyway. And I say, listen, there's a lot of ways, and it's the same reason why I ask them to reduce medical liens too. So whether it's a medical lien or an ERISA lien, we get the lien, we check the amounts, we make sure the amounts are correct, we make sure they're not exaggerating, we make sure that the billed amounts they're asserting for that lien are accurate, and then we say things like, hey, you're getting a free lawyer to go be a bill collector for you. Why don't you knock a third of it off, and then I pass those savings on to my client. Or we say, hey, let's look at your bill. I know we went to, we had this, one of the examples, I give two good ERISA success stories. One of them in the appendices. One of them is we had a $76,000 lien that was literally reduced to $165. And a lawyer came in, and I was calling, we were writing, and I picked up the phone and called him. We do so much on the phone or emails. Sometimes it's good to pick up the phone and call because you can cut a deal. And the lawyer saw it right away. And what I do is, the other thing I do is I take the defendant's position against me in the underlying case to the lienor holder. So I say, hey, the city of St. Louis is defending this case and saying that none of this medical is related. They hired an expert. He came in. Here's his expert report. Here's the depo I took from him. We settled this case for $10,000, and you want to get the $50,000 in the lien. This medical is not related. And I take all the work that the defendant did against me to show to the ERISA lien holder, saying none of this medical is related, write it off, get rid of it. Because it's true, right? None of the arguments that I'd ever use with a lien holder aren't true. Otherwise, they call BS on what I'm saying to them. So you really meld the reality of your case with what's going on. I also had a case one time where we've had a lot of different examples, but the other thing is that what if you have a client with $250,000 in medical bills and a $50,000 or $25,000 auto policy? Well, then if you're going to settle that case, then your client is going to be substantially undercompensated. And you need to go to the lien holder and say, listen, my guy's taking 10 cents on the dollar because, his damages really are $1 million, but there's a $50,000 policy. He's taking 10 cents on the dollar. Concomitantly, you have to reduce your lien and see where that goes. Now, again, these are equitable principles. A lot of times, even though technically they'll quote this McCutcheon case to you, they'll send you mean letters and stuff, but if you pick up the phone and call them, we've had a lot of success with that. Because then we say, listen, no offense, but we ain't ever going to settle this case. My client has zero incentive to go litigate and try a case for $50,000 where you're going to insist on a $250,000 lien. It's just going to happen. We're going to let it go away. and you can't, and all you have is a subrogated interest. You can't be the first party in that case. You can't go sue for that. You can't do that. And so why would my client do that? We had an example earlier today about that, and I gave them some ideas. Is you can go file a declaratory judgment action. There's a lot of things you can do. The other thing you can do is you can resolve the ERISA. You can do a motion to adjudicate the ERISA lien in the state court case. You can. I did it. I have the petition. I have the motion to adjudicate lien. I have the order and that kind of stuff. So, can I? Kind of not, right? Because ERISA, it's exclusive federal court jurisdiction. But I don't. I go to Optum or these other companies and I say, will you reduce it? Will you reduce it? No, no, no. We had this case with Anthony Castro. It's in the material. It was a huge lien, $1,800. But I'm cheap. So what I did was, and I said, and they only offered me a 10% reduction, and I happen to, his dad has been fixing my cars for 30 years. They're the salt of the earth. They're the nicest people in the world. And I said, you know what? I don't think that's fair. So we went, and they said 10%, and they kind of ignored me. I did a motion to adjudicate the lien in the state court case. I put them on the certificate of service. I sent it to them. I went and argued in front of the judge because a court has the inherent jurisdiction to resolve all liens before it. They asserted a lien in the case. The court has inherent jurisdiction to adjudicate and resolve liens in that case. They never showed up. They're not going to show up for $900. And we went and we got it. And then they sent me another letter, and I sent them the court order. You guys never came. Here's the court order. That lien is done. They took the payment. We're done. And you do the similar thing with the other. You can also do the similar thing with the other liens in the case. You do a motion to adjudicate the lien in that case, and the court has the power to adjudicate those liens. I did it in Springfield, Illinois last year, and you'd be amazed. We're not. It's kind of like a lawsuit. You know, I file more lawsuits these days. We're not paying you anything more than this, more of this. We go file a lawsuit, all of a sudden you got a new adjuster and they're paying you more money. On the lien issue, we're not going to reduce it anything below this. We're not going to reduce it anything below this. You file a motion to adjudicate lien, you set it out, and boom, it's amazing what they do. Because all you're doing is asking. If all you're doing is asking for the right result in the first instance, then you're fine, right? So you know, the other thing you do is you look at the bill. You say, hey, you're a chiropractor and you charge $500 a visit. You got 5 visits and the bill is a huge amount of money. And that's not fair because you wouldn't charge a health insurance companies only give you $50 a visit anyway. You're loading up bogus charges on this bill. That's inappropriate. You got to reduce the bill. So you got to examine the bills for that. And then the other thing you do is if they're refusing to reduce or negotiate with you, you hold the money in your trust account and don't resolve it. I have this happen many times. You have the case. You settle the liens you can. This chiropractor is reasonable. By the way, ambulance guys, they never take any. It's hard to get money off, but the bills are only $700. If you can get a couple $100 off an ambulance bill, you're great. By the way, Carpenters Union, it's an ERISA plan. They're never going to negotiate off it at all. Give it up. You got to pay the whole thing. Maybe 10%, 20%, and they got a great argument. You call them up and they say, we have to get this money back so we can provide. We're a self-funded plan. We need this money back because we got to pay for the insurance coverage for the rest of our carpenters. And they got a great argument, and they win every time in court. They really have a good argument, and that's fine. But if you have someone who's refusing to negotiate, you sit and you leave the money in your trust account, and you haven't not honored the lien, you haven't dissipated the money, it's sitting there, and you just say, listen, you'd be amazed at 6 months later what they'll take if they didn't take it the first time. And you write in your settlement letter with the client, we do it all the time, saying we were able to resolve this, and this lien. This is how much money we saved you. I always say that, and we literally tell them, and they think you're great because you did it. You don't charge them for that. That's part of the service. I think we have these contingency fees. We get as much money as we can on the front end from the defendant in the case. You also reduce the liens as much on the back end to put as much money in their client's pocket as possible. The client doesn't care whether you fought and got another $2,000 from the defendant or whether you negotiated the lien down $2,000 extra and put that in their pocket. It's the same to them. I leave it in my trust account, and then they keep calling, and the conversation is funny. They say, we're only going to take this. I go, okay. And they go, okay, you agree? I go, no. Okay. the money's going to stay in my trust account. When you realize the wisdom of my position, you call me up. And then they'll send me letters every once in a while. And I'm not being a jerk. I'm just being steadfast in my position. And then they'll call you up, and down the road, they'll pay you. That happens a lot. Mike, our great associate, took a phone call yesterday from we have this chiropractor. He saw my client 5 times. We settled the case. The bill's $1,200. It's not fair. I kind of always think about $100 a visit for my people on a chiro. That's pretty good. If it's a little bit more, that's fine. I'll pay it. But this is way out of whack. And so I sent the chiropractor, but I told him I'd say I'll pay you $600. And he's mad at me. So I sent him a check for $600. I didn't say payment in full. I didn't play any tricks. I just said, we don't dispute. I owe you $600. Here's the money. I'm going to keep the other $600. And he called up yelling yesterday. So, but that's fine. Whatever. You also want to temper your advocacy to reduce the liens with what is fair to the healthcare provider. Because there's great healthcare providers out there that do our clients huge favors and huge bonuses, right? So if it's a good chiropractor and he treated your person 35 times and really got him back to health, he should get paid and should get paid well. And you really shouldn't jerk that person around. Similarly, if it's an orthopedic surgeon or some of these other people, they should be treated fairly. So you don't go overbroad. You want to be what's fair, and you sit and talk to them, and you may not realize. They say, I did this and this, or I go, okay. The other thing is you want to be vigilant about is an insurance, a medical provider who got paid by health insurance and now wants more money. They can't do that. So the medical provider has a contract with the insurance company to get paid a certain amount of money, 20%, 40%, whatever percent it is of the money, and they got to take that. And your client who pays for the insurance premiums is a third-party beneficiary to that contract between United Healthcare and St. Luke's. And you get the benefit of that contract, so they can't come at you for more money. There's great case law on that. St. Anthony's used to, remember this? What St. Anthony's did for years is they would get a case, they'd bill the health insurance company, they'd get paid, they'd figure out there's an automobile case, they'd pay the pay the health insurance company back their money, and they'd put a lien in your case for the full amount of the thing. Because they made a corporate decision that instead of getting paid 30 cents on the dollar for that, they're going to make more money asserting a lien in your personal injury case. But they can't do that because you still have that contractual right to be paid by your health insurance company, and they can't obviate that. There was a number of big cases against hospitals in Kansas City that won some big verdicts about 2 years ago, I think. And I looked into a class action. We were talking class action case against St. Anthony's that it didn't go anywhere. Some other lawyers were already doing it, but anyway. So they can't do that. So make sure you look at the bills. The other thing is get the medical bills right away, and then get the medical bill later. One of the cases, we argued. We're waiting on the order. We had a case. We litigated. We settled it. The bill we had from St. Luke's showed that they were paid by insurance, and there was a $200 very low balance. That my client, $2,000, my client already paid it. $27,000, he paid $2,000, we're done, insurance paid $25,000. We settle the case, St. Luke's asserts a lien for $25,000, the case was done. My client's like, what the hell, what are you doing? He's nice, but he was upset. They send us a new bill. After the bill that we had 3 months later, the United Healthcare came and took their money back because they thought it was part of a work comp case, but it never was. So then St. Luke's has a $25,000 bill, and United Healthcare didn't pay. 2 years later, when we're resolving this, we apply to United Healthcare, and we say, hey, you got to pay this. You improvidently took the money away. They say you missed the 6-month time period to appeal this. We say, we never knew about it. They say tough cookies. And then, so he can't avail himself for that. So we fight St. Luke's. St. Luke's comes in and says that, this is a good, so they come in and they say, we didn't perfect the lien. So we don't have a lien, so you can't use the lien statute against us because we never sent it by certified mail. And then I say, well, wait a minute. You're in here in this case asserting a lien de facto. That's why we're here arguing this anyway. So we briefed both sides of it, and we're waiting on a decision. I hope we win. I think we will. The provision under which that was addressed is .225 subparagraph 5. The other thing you do in resolving liens is what I call the lien reduction statute or the lien cram down statute. And we talk about that in section 3 of, mostly section 3. So here's what this says. And there's one in Illinois and there's one in Missouri. And while we're here, the other thing, in addition to reviewing our firm on Google, both you get an email me for that both here and in our other locations, which we would greatly appreciate. And if you guys go through and you're associated with a firm or someone else and I did not review you, please let me know and I'm happy to. We had a good seminar in December. We talked about marketing and how to market our practices. We had some different people coming in and doing that. Those materials, we had extra materials for that. If you need the materials for that, email me and I'll send them to you. One of the things we do in marketing, because everything's social media these days, is talk about Google reviews and that kind of stuff. But the other email you got from me is our Excel spreadsheet. So my amazing paralegal, Casey, put together these Excel spreadsheets on these two lien statutes, both in Illinois and Missouri. And here's what they say, is that, and this happens if you have a case where your damages are higher than the insurance liability coverage. So you got $50,000 in medical damages, but you only have a $25,000 minimum policy. What do you do? Or, and more similarly, it's like, well, what if you have even 12, 13 in liens? You got to pay that out, and there's $25,000 in fees. Well, $25,000 coverage. Well, after your third fee, that's $16,000, and you got to pay $12,000 out on a lien. What do you do, right? Oh. Here's what you do. So you use the lien statute, and this cram down lien statute. What it says is that out of the total settlement, you take out attorney's fees and expenses, and then whatever is left, half goes to the client and half gets split pro rata among the lien holders. So that $12,000 in liens gets split with $8,000, because if you have the guy has 16 left over after your reasonable fees and expenses, you take that in half. The client gets $8,000, and that $8,000 gets split among the lien holders. Okay, and while we were sitting here, I emailed you an Excel spreadsheet on how to do it, and I do it all the time. I try, and there's other circumstances that it happens. What happens if it's a terrible liability case, and it's a slip and fall, and your person was already using a walker, and there was ice there, and they never treated it, and blah, blah, blah. Well, sometimes, and you have a lot of medical. What if you have a guy had a hip replacement or something? You have a ton of medical. It's terrible liability. You need to settle the case anyway because you may lose. So you take $50,000, you take the $100,000 in liens, and then the client gets. You take your fees and expenses out. Then of the amount that's remaining, half goes to the client and half goes to the split pro rata among the lien holders. And what we do, and we have these letters and stuff, is we're absolutely transparent about it to everybody. Because the benefit that you give to your client is not only do you settle the case, but they don't have these bills chasing after them forever. And it's really a benefit. So, so we have a letter to each of the lien holders. We settled the case for this. Our fees and expenses are this. Under RSMO 430.225.5, this is on page 5-ish of my stuff. Under this statute, the client gets half, and you guys split half. Attached to here is our Excel spreadsheet, setting it all out, and closes a check for blah, blah, blah. We don't ask them to agree, and we don't say payment in full. We say under this statute, paragraph 5, this is all you're going to get. You cannot sue my client for anything more. And that's the deal. And I've used it for years and years. Every once in a while I had a problem with it. not from that it's not valid. I had a guy, we settled a case in Springfield recently, and the lawyer wasn't familiar with it, and he said, well, we want all these people to release it. I go, they ain't going to release it because they're really going to get pennies on the dollar. But here's the deal, and here's the statute. And so they finally tipped to the wisdom of our position, and they sent us the checks, and they broke them down. We sent them out. We'll never have a problem. Part of my deal with my clients is not only am I taking this contingency fee out of this case, but I will represent you forever on anything related to this case. I got your back. So if anybody comes back a year, 2 years down the road, tries to sue you on this, I got the file. I'm going to defend you for free. And I've never had a problem, literally never. And it's not because I'm brilliant or anything. It's because we do it right the first time. We know the law, and we're not overreaching. If you're going to try to sneak around or overreach or cram down one too inappropriately, then maybe you have problems. All right? Does anybody have a question so far? Because I'm talking fast because I've been drinking coffee all day.
Gary, are you including providers that have not given you a lien in when you do that?
Brilliant question, which is exactly what I was about to say. Here's the other thing we do. So in those cases, it's funny. You have these cases, you agonize over it, you work so hard, and then you call the client up and you say, we're trying to settlement, they're only offering this. And then your client says, well, really, all I want is the medical paid and a couple grand in my pocket. Brett's been doing this a long time. And you're like, oh, damn, I've been keep up at night. That's all you want. I could have done that 6 months ago. But anyway, and that really is what they want. Most of our clients aren't overreaching, and if they are, that's not a client you want anyway. And so here's what else we do to give our client, to give that help. What if you have 5 medical providers, 2 of them asserted liens and 3 didn't? To your point, here's what we do. We send them a letter inviting them to assert a lien. Before we tell them we're about to kind of rip them off a little bit. Not rip them off. We're going to use the protection of the lien statute, which is well afforded to Missouri citizens. And we do. We send a letter saying, hey, we got this case. We know you have this bill. Assert a lien under 225. Sign this and send it back. And they do. And then a couple months later, and just like when we were talking about Daubert, I forgot this point, that you got to think ahead of time. When you're dealing with liens, think about it ahead of time. Double down, own it, judo it. And that because start thinking about those liens ahead of time so you can start getting this ready to go. A great way, I forgot to say this morning, another great way to negotiate liens is get the first lowball offer from the insurance company for $5,000 on a $30,000 case. Take that and send it to the lien holders. Hey, I only got $5,000 offer. Here's the letter. Whenever we get, and you guys know this, 2 of our great associates are here, whenever we get a lowball offer from the insurance company, I say scan it, send it to the client so they know that whatever we get, we're really fighting hard for the money. The other thing is you send it to the lien holders, and you're like, hey, here's the first offer. Are you going to get more? I don't know, because after discussions that are kind of fluid. So what you do is while you're negotiating with the defendant, you're also negotiating with the lien holders on the other side. Say, hey, I'm getting a little bit more here. They're only at this. And that way anyway, try to negotiate the liens. You get them committed to numbers, and then you go to the defendant and you get a little bit more money, right? And you've already established that. But what we do is we invite the people to assert liens, and then we do it. The other thing we do is we send letters of protection so that when your clients are getting bill collectors and getting calls and stuff, they don't want to get those. Let me send you a letter of protection. You're doing them a favor. Here's a letter of protection. Please don't call them anymore. Now, the collections agency isn't bound to take that, but oftentimes they do it. And tuck it at the end of the letter. And as an extra bonus to you, I'm granting you a lien in this case pursuant to blah, 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 blah. And they got a lien on that, and then you do it. So that's what you do. The other thing we do is when we do this spreadsheet and we cram down the liens in these cases. Now, again, hopefully in many of the cases we get these great recoveries, these $1 million verdicts. That's the only thing I put on my walls or in the Lawyers Weekly. But the other thing we do is when we do these is this is where I take a little artistic license, but I don't mind sharing this idea. This is great. This is the gem. This is what you're waiting for. You ready?
Ready.
All right. Here's what you do. You put the ERISA lien in with all the other liens, and you cram them all down. So you send a letter, and you say, and what I do is I don't care if they have a lien or not. and this works 99% of the time, is I sit there and I'll say, here's the 10,000, and if I'm throwing around numbers, they're all in my brain. I can write them up here or whatever. You guys, please interrupt me and ask me if you're not following me, because I know I'm cruising through a lot of material. After you take out the fees and expenses, half goes to the client. Then what are you dividing pro rata in the other half? I will put in the ERISA lien in there, and I'll do the same letter to them, and I'll tell the ERISA people, we're cramming you down, blah, blah, blah. And because I don't like paying money to insurance companies. I feel they rip off people already, and the more I can do for my folks, I can. And I'll put the other bills, whether or not they're sort of lien, and then I do that letter to them. I contain the whole spreadsheet, so I'm transparent. I'm not misrepresenting anything at all, zero. And I want them to know that, and lien holders will do that. We have one pain management guy who I love. I've been to lunch with him many times, but every time he always wants to know, is everybody else taking a reduction? And if everybody is, he's cool with it. If they ain't, he ain't. And he's great. He's a great guy, and he does great. He's a great doc. He attends to these himself. So, but you put it, and I attach a spreadsheet. I show them all. Here it is. Now, if they want to call me, now when I do the letter to the client, I say, hey, I tucked the ERISA lien in on this, and technically it's a federal court case, and technically they're not bound by this. But then again, the other lien holders aren't. If they haven't perfected a lien, do you know how many people send certified letters to Liberty Mutual and State Farm to perfect their lien? Nobody, ever. But they want to honor that, and you want to take those liens in. So technically, could these people come in and say, like they did in my St. Luke's case, we never sent it by certified mail, so it's not really a lien, so we're not bound. They could do that, rarely do. So I put it in, but in the letter to the client, I say, hey, just so you know, I put an ERISA lien in on this and reduced it, and this is what I reduced it by. But if they have a problem with it, we may lose that legal position. But I think I have a good faith basis to make that. I'm gonna. So you say that to them and you let them know, transparency and fully inform your client. The other thing you do, though, it's important, is keep that money in your trust account for a while in case you get called on it. So I'll say, we reduced the ERISA lien from Optum from $2,500 down to $1,200, but I'm going to keep that extra $1,300 in my trust account for a period of time until we let the dust settle and make sure no one's going to complain about it. And then when you send them a letter, just like with the ERISA lien, the other time you say, hey, we reduced it, we took this position, it's possible you could have this debt later, but I've done this to save you money. So that's what I do. On the ERISA lien.
How long are you keeping it in your trust?
I don't know.
A year?
No, a year's really long. What I'll do, I'll diary it for 6 months, and then if that's boom, boom, and they'll call you. I mean, I'll call these people too. A lot of these. So Carpenters Union is never going to pay you, but I also have had very good luck picking up the phone and calling these. This is a person sitting in a cubicle in Atlanta, Georgia, for Optum. I think that's where they are. Where are they now? Who's Optum now, Casey?
Eden Prairie, Missouri, Wisconsin.
Yeah.
All right. So Casey's really good at it too. The other thing is you can systematize this. If you have people working with you, you teach your paralegals and your lawyers how to do it, so you're not sitting there fighting liens all the time, which can get a little tiresome. Pick up the phone and call them, and sometimes you get people who are just want to fight, and then you got to do this. But sometimes you can say, here's the deal. Here's my medical. Here's why we're reducing this low. You got a free lawyer. This case did not settle easy. I mean, I'll literally tell people, let me tell you what I did. Because they'll say, did you reduce your... If they ever ask you, did you reduce your fee? They're itching for a fight. But I'm going to say, listen, I litigated this case for 3 years. I'm making $20 an hour on this case anyway. So don't be talking to me about this. You got a free lawyer to go be your bill collector so that you can, and you're getting, and you're Optum, you're getting 15% of this. That's why you're motivated in this. And then they say, well, I don't have authority about that. And just like when you talk to try to settle a case, well, go talk to someone who has authority. Right? Oh, I only have authority to settle a case for this month. Can you call and get some more authority? We always do that, right? It's like the car salesman thing. The manager comes in to sell a car. Well, we can't do. Well, go talk to your manager. Any questions?
I have a question.
Yep.
So Illinois resident, Illinois insurance contract goes over to Missouri for trauma, level 1 trauma care at Barnes or SLU. Which lien statute do you use?
ERISA plan or not? Or is it just a medical lien
The
holder?
medical liens.
It's a Missouri plan. It's a Missouri statute.
So you use the Missouri instead of the Illinois?
Yes.
Okay.
The Illinois statute would only apply to cases pending in Illinois. That's what I think. And so the Illinois statute is a little different. You take the fees and expenses out, the client gets half, but then they divide it up between medical providers and medical doctors, between hospitals and other providers.
Okay. So
It's
we
a little
haven't
bit
filed it
different.
yet. It's pre-litigation.
Sometimes, the other thing you do is you can squeeze the lien holder by saying, listen, why would we pursue this case? Why don't you reduce it? There's other things you can do.
Okay. I just wasn't sure which one was better. If anyone ever did the calculation, which one really worked out better.
Did we send that email? You just got
Those
two spreadsheets. Put the numbers in and see. Aren't they pretty much the same, Casey?
works out the same.
Casey's better at negotiating liens than anybody I know.
They make you reduce your fee a little bit, and they're divided into professionals and providers. So
Right.
hospitals and doctors are separated.
All right. So I'm going to we're going to get everybody out of here in 2 minutes, but I'm going to shoot a bunch more information at you. I'm going to talk really fast. All right. So in Section 5, we have the Medicare and Medicaid lien and how to resolve them. Everything you ever need to know about it is in here. Casey wrote it. If you guys ever have any questions about liens, call my phone, ask for Casey. She'll answer any question you got. Medicare, you fill out the proof of representation form. She wrote this, by the way. You fill out the proof of representation, and Mike wrote the expert thing that I did earlier, and Joel edited everything to give everybody else credit. You fill out the proof of representation form. 65 days later, they're supposed to do a conditional payment letter. You used to have to write to request a conditional payment letter. You don't have to do that anymore. So that's and then they'll do it. And Medicare, everybody's afraid of Medicare, and so Medicare. Did I talk to you about informal opinion 125 yet? No. You cannot personally guarantee your client will pay a lien. It's unethical under informal opinion 125. So you can have your client agree in a case to pay all liens with the defendant, but you can't say the lawyer will agree to it. Okay? Because when you settle these cases, they're going to say, we got these liens. And then you say, well, pay me the whole $25,000 check and I'll pay the liens. Sometimes they'll do that, but sometimes they'll say, no, we don't trust you. We're going to do a check for $1,000 to this Cairo, some to this Cairo. Now, I've been doing this for a long time and I've never had a problem. So most of the lawyers on the other side know me and they'll say, we know you're going to do it. Don't worry about it. Here it is. But if they don't know you're unseasoned, or they may insist on separate checks for the different amounts. And I say that's fine. I always say, you guys do whatever you want. You want me to protect and identify? You want me to negotiate the liens down and then me tell you the different amounts, and then you'll parse it out and we'll do the different checks a different way. Right? Got it? So then I'll go negotiate the liens the same way I always did, and then I'm going to get them to do the checks. $1,000 to this guy, $3,000 to me, $21,000 to my client, and me to go in my trust account. All right. The same thing, you would be surprised at how Medicare and Medicaid, you get them on the phone, they'll reduce it too with the same arguments I did before. They're people, they get it, they got discretion. You're not going to rip them off, but if you go and say, hey, listen, here's the deal, da-da-da-da, they'll be fair to you. Workers' compensation liens, it's a formula called Rudiger. It was then codified in Section 287.150. This is a great worksheet. This is exactly how to do it. Put this in this space, put this in this space, divide this by this, multiply it by here. Here's the amount of the work comp. In work comp, settle the comp case first before the civil case. And then there's a lot other here. There's some other formulas, but that's what settle the comp case first. And then here's the formula on how to determine the lien. The other trick is, though, if you ever have a case where you're going to have a huge lien, take less on the comp settlement and get them to waive their subrogation. Most of the time, the left hand doesn't know what the right hand's doing. So the left hand of the work comp adjuster doesn't care about the subrogation department. So he'll throw them under the bus to look better. So you can say, listen, I know I could get $20,000 from you in the comp case, but tell you what, I'm going to cut you a deal. I'm going to only take $10,000 and you waive subrogation. And then you go and you just made your client an extra 20 grand on the subrogation lien. Does everybody understand what I said? I'm getting some curious looks. Doug?
That's a great idea.
So here's what you do, right? You've done this. Have you done this? So if you've got a work comp case, and we have a work comp case right now where the paid benefits are $35,000. So their lien is going to be about 20 grand if you do the math. They were at 3 grand and I was at 7 or something. And I said, listen, I'll take the 3 but waive subrogation, meaning that we'll only get paid 3 instead of 7 grand, 4 grand difference. But then they're going to waive their right to get $20,000 out of the civil case, and I have good liability. I got a $100,000 policy, and I'm going to be able to do that. So they waive this. They completely waive it. They waive the subrogation lien. You take a couple grand less on that, and you go get the. Then they don't get to do it. And sometimes the adjuster on the and subrogation departments are always separate, and they're kind of stepchildren. So. You take less and they say, you know what, do this, but waive it. And then if you can get under the radar. I didn't get under the radar on the one. They said, nope, the lawyer's been doing it forever. He knew exactly what I was doing. He called me, and and then they refused to do it. And I had to, anyway. Well, you try, right? All right. So, all right. FIBA liens, it's Section 7. You're never going to run into it. But there's a recent case, the U.S. Supreme Court, from the Missouri Supreme Court, that says that if an employee gets a federal benefit, those FIBA benefits have the same ERISA preemptive power, the same preemptive power that was decided for ERISA. So you got to pay those back. They're powerful. Attorney's liens, I could do a whole seminar on attorney's liens. You can tell that I work with these liens and this stuff. So attorney lien, the statute's powerful. The statute for attorney's liens is more powerful than the medical lien statute. So if you're an insurance company and you're the second lawyer on it, they better waive that prior attorney's liens, otherwise they're in trouble. Because you can go get paid twice. You got to honor that attorney's lien. If another lawyer had a case for a long time, then it comes to you, and I get those sometimes. You got to deal with the prior lawyer. The prior lawyer has a lien for his services. If the contingency in the contingency agreement has not happened, some of us get in fights about this stuff. And if that hasn't happened, then that contingency fee agreement is gone. But they have a quantum merit or equitable entitlement to their time. Most people think, they automatically get $100 an hour, $150 an hour. That's not true. I put the case law in here. It's an equitable remedy subject to equitable defenses like latches, unclean hands, whether you did it, right? And I've had this. I've argued this. I got it right now, and I had the letter. Oh, I have it. Anyway, it really aggravates me. I sat on the Ethics Commission for a long time. The 2 most frequent ethics complaints against lawyers are diligence and competence. And it really aggravates me when a lawyer has a case for 3 years and doesn't do squat, and then the client is mad, and then they think all lawyers delay things, and et cetera, et cetera. And then they finally get up the gumption to fire that lawyer. They come to me, and then I go settle it, do a bunch of work, we get a good result in the case, and then that lawyer wants a full fee. And I'm like, you sat on this case for 3 years, you didn't do squat, and now you want 10, 20, 30, 40, 50 grand. Are you kidding me? However, there is I argued this in front of Judge Durker one time. Did someone talk about Durker here, or was it earlier? Oh, you did. I argued in front of Judge Durker against a lawyer that I kind of knew, and I said, listen, don't make me do this, but I don't think it's fair. We argued in front of Durker. He turned to the other lawyer and said, how many hours you have? 20. He gave him $2 grand. He said, here's your hourly rate. Just gave it to him. So there's a lot of judges that don't think that and want to look out for the lawyer getting paid. A lawyer should get paid, but a lawyer should get paid fairly. And so I always go to these other lawyers. I say, listen, I'll give you some money. Why don't you take this or this? I think that's about fair. And then they say, no. Well, you try to resolve it. The ethics rule on fee disputes, I'm jumping around trying to do it quick. There's a lot of law here. The ethics rule on fee disputes says that a lawyer shall consciously consider using a fee dispute committee and resolving disputes with lawyers among fees, whatever that means. But using a fee dispute committee and resolving it in an informal forum rather than having to do it in open court is a good tack to go, and so you should try that, and we do that too. But they might not. We have one referred to a fee dispute committee. The other lawyer won't do it. So I'm like, I don't know. What am I supposed to do?